Law of Human Rights. Meaning and definition of human rights, concept of human rights. Meaning and definition of human rights. Meaning human rights. Human rights are standards that recognize and protect the dignity of all human beings. Human rights govern how individual human beings live in society and with each other, as well as their relationship with the state and the obligations that the state have towards them. Human rights law obliges governments to do some things, and prevents them from doing others. Individuals also have responsibilities. In using their human rights, they must respect the rights of others. No government, group, or individual person has the right to do anything that violates another's rights. Definition of human rights. According to Sector 2, D, of the Protection of Human Rights Act 1993, human right means the right relating to life, liberty, equality and dignity of individual guaranteed by the Constitution and embodied in the international covenants and enforceable by courts in India. According to Dr. Purohit, human rights are the basic values which underlie that human beings born in any part of the world are equal in dignity and rights. Concept of human rights. Evolution of human rights. Historically, Code of Hammurabi Babylon 1754 BC describes human rights. In modern age, Magna Carta can be considered as source of present human right evolution. Magna Carta. Magna Carta, also known as Great Charter, is a charter of rights agreed by King John of England on June 15, 1215, to make peace between the unpopular king and group of people. It promised to protect church rights. Magna Carta inspired many people as Thomas Jefferson to Mahatma Gandhi. Magna Carta has lived over 800 years and is echoed in the United States Declaration of Independence and the UDHR, United Declaration of Human Rights. Perhaps Magna Carta's most important legacy is that everyone, including our leaders, must obey the laws. What stated out as document of specific compliance from a group of barons has turned into an international symbol of liberty without which we might not have the rights we value so much today. Petition of Right 1628. A statement of civil liberties sent by the English Parliament to Charles I, human rights were improved as enhanced in the petition. The Bill of Rights 1689 is a landmark act in the constitutional law of England that sets out certain basic civil rights. It is to be noted, it did not include social, economical, or political rights. The Virginia Declaration 1776 declared that all men are by nature equally from and independent and have certain inherent rights. Constitution of USA 1787, with amendment in 1789, 1869, and 1919 specified a number of FRS of man. French Declaration 1789. Inspired by the American Declaration of Independence, proclaimed the Declaration of the Rights of Men and Citizen. UDHR, Universal Declaration of Human Rights 1948. Is a historic document that was adopted by United Nations General Assembly. UDHR is a milestone document in the history of human rights. It sets out for the first time fundamental human rights to be universally protected. International Covenants 1966. The United Nations General Assembly adopted two covenants on December 16, 1966, the International Covenant on Civil and Political Rights, ICPER, and International Covenant on Economic, Social, and Cultural Rights, ICESCR. Object of human rights: to protect human being, to develop individual self-respect, to value human dignity, to promote respect and understanding and appreciation of diversity, to promote democracy, social justice, friendship among people and nations. Sources: UDHR, Universal Declaration of Human Rights. International Treaties and Covenants. International Customs. Judicial Decisions. Official Documents. Human Rights and the United Nations. A. Charter Provisions, B. International protection of human rights. Human rights and the United Nations. Human rights are the basic fundamental right and freedoms that belong to every person in the world. United Nations is an intergovernmental and international organization that aims to maintain international peace and security, develop friendly relations among nations, achieve international cooperation and be a center of harmonizing the action of nations. History of United Nations. In 1945, after World War II, world wanted peace. The document of United Nations Charter was signed by 51 countries. Charter provisions. The United Nations Charter contained as number of provisions for the promotion of human rights and fundamental freedom. Preamble talks about equal rights of men and women. Article 1. Article 1 talks about respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion. Article 68. The Economic and Social Council shall set up commissions in economic and social fields and for the promotion of human rights, and such other commissions as may be required for the performance of its functions. Article 68 became base for international covenants and ECOSOC, Economic and Social Council. ECOSOC, Economic and Social Council. ECOSOC appointed a Commission on Human Rights which was approved by the General Assembly on February 18, 1946, and to commission was called United Nations Commission. This commission was empowered to carry out studies related to human rights, make recommendations, and draft new international treaties. The Commission on Human Rights established the Subcommission to protect interest of minorities. They drafted a Bill of Rights on the principles of human rights. This draft was called UDHR, adopted by the General Assembly on December 10, 1948. International protection of human rights. The Universal Declaration of Human Rights is generally agreed to be the foundation of international human rights law. Adopted in 1948, the UDHR has inspired a rich body of legally binding international human rights treaties. UDHR has inspired more than 80 international human rights treaties and declarations, a great number of regional human rights conventions, domestic human rights bills, and constitutional provisions. This together constitute a comprehensive legally binding system for the promotion and protection of human rights. How does international law protect human rights? International human rights law lays down obligations which states are bound to respect. By becoming parties to international treaties, states assume obligations and duties under international law to respect, to protect, and to fulfill human rights. The obligation to respect means that states must refrain from interfering with or curtailing the enjoyment of human rights. The obligation to protect requires states to protect individuals and groups against human rights abuses. The obligation to fulfill means that states must take positive action to facilitate the enjoyment of basic human rights. Universal Declaration of Human Rights. Preamble.
Whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice and peace in the world. Whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of the common people. Whereas it is essential, if man is not to be compelled to have recourse, as a last resort, to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Whereas it is essential to promote the development of friendly relations between nations. Whereas the peoples of the United Nations have in the Charter reaffirmed their faith in fundamental human rights, in the dignity and worth of the human person and in the equal rights of men and women, and have determined to promote social progress and better standards of life in larger freedom. Whereas member states have pledged themselves to achieve, in cooperation with the United Nations, the promotion of universal respect for and observance of human rights and fundamental freedoms. whereas a common understanding of these rights and freedoms is of the greatest importance for the full realization of this pledge. Now, therefore, the General Assembly proclaims this Universal Declaration of Human Rights as a common standard of achievement for all peoples and all nations, to the end that every individual and every organ of society, keeping this declaration constantly in mind, shall strive by teaching and education to promote respect for these rights and freedoms and by progressive measures, national and international, to secure their universal and effective recognition and observance, both among the peoples of member states themselves and among the peoples of territories under their jurisdiction. Articles. Articles. Article 1 to 2 are about general. Article 3 to 11 are about individual rights. Article 12 to 17 are about civil and political rights. Article 18 to 21 are about religious rights. Article 22 to 28 are about social, economic and cultural rights. Article 29 to 30 are about duties. Article I. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Article 2. Everyone is entitled to all the rights and freedoms set forth in this declaration, without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. Furthermore, no distinction shall be made on the basis of the political, jurisdictional or international status of the country or territory to which a person belongs, whether it be independent, trust, non-self-governing or under any other limitation of sovereignty. Article 3. Everyone has the right to life, liberty and the security of person. Article 4. No one shall be held in slavery or servitude. Slavery and the slave trade shall be prohibited in all their forms. Article 5. No one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. Article 6. Everyone has the right to recognition everywhere as a person before the law. Article 7. All are equal before the law and are entitled without any discrimination to equal protection of the law. All are entitled to equal protection against any discrimination in violation of this declaration and against any incitement to such discrimination. Article 8. Everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted him by the Constitution or by law. Article 9. No one shall be subjected to arbitrary arrest, detention or exile. Article 10. Everyone is entitled in full equality to a fair and public hearing by an independent and impartial tribunal, in the determination of his rights and obligations and of any criminal charge against him. Article 11. Everyone charged with a penal offence has the right to be presumed innocent until proved guilty according to law in a public trial at which he has had all the guarantees necessary for his defence. No one shall be held guilty of any penal offence on account of any act or omission which did not constitute a penal offence, under national or international law, at the time when it was committed. Nor shall a heavier penalty be imposed than the one that was applicable at the time the penal offence was committed. Article 12. No one shall be subjected to arbitrary interference with his privacy, family, home or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks. Article 13. Everyone has the right to freedom of movement and residence within the borders of each state. Everyone has the right to leave any country, including his own, and to return to his country. Article 14. Everyone has the right to seek and to enjoy in other countries asylum from persecution. This right may not be invoked in the case of prosecutions genuinely arising from non-political crimes or from acts contrary to the purposes and principles of the United Nations. Article 15. Everyone has the right to a nationality. No one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. Article 16. Men and women of full age, without any limitation due to race, nationality or religion, have the right to marry and to found a family. They are entitled to equal rights as to marriage, during marriage and at its dissolution. Marriage shall be entered into only with the free and full consent of the intending spouses. The family is the natural and fundamental group unit of society and is entitled to protection by society and the state. Article 17. Everyone has the right to own property alone as well as in association with others. No one shall be arbitrarily deprived of his property. Article 18. Everyone has the right to freedom of thought, conscience and religion. This right includes freedom to change his religion or belief, and freedom, either alone or in community with others and in public or private, to manifest his religion or belief in teaching, practice, worship and observance. Article 19. Everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive and impart information and ideas through any media and regardless of frontiers. Article 20. Everyone has the right to freedom of peaceful assembly and association. No one may be compelled to belong to an association. Article 21. Everyone has the right to take part in the government of his country, directly or through freely chosen representatives. Everyone has the right to equal access to public service in his country. The will of the people shall be the basis of the authority of government. This will shall be expressed in periodic and genuine elections which shall be by universal and equal suffrage and shall be held by secret vote or by equivalent free voting procedures. Article 22. Everyone, as a member of society, has the right to social security and is entitled to realization, through national effort and international cooperation and in accordance with the organization and resources of each state, of the economic, social and cultural rights indispensable for his dignity and the free development of his personality. Article 23. Everyone has the right to work, to free choice of employment, to just and favorable conditions of work and to protection against unemployment. Everyone, without any discrimination, has the right to equal pay for equal work. Everyone who works has the right to just and favorable remuneration, ensuring for himself and his family an existence worthy of human dignity, and supplemented, if necessary, by other means of social protection. Everyone has the right to form and to join trade unions for the protection of his interests. Article 24. Everyone has the right to rest and leisure, including reasonable limitation of working hours and periodic holidays with pay. Article 25. Everyone has the right to a standard of living adequate for the health and well-being of himself and of his family, including food, clothing, housing and medical care and necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age or other lack of livelihood in circumstances beyond his control. Motherhood and childhood are entitled to special care and assistance. All children, whether born in or out of wedlock, shall enjoy the same social protection. Article 26. Everyone has the right to education. Education shall be free, at least in the elementary and fundamental stages. Elementary education shall be compulsory. Technical and professional education shall be made generally available and higher education shall be equally accessible to all on the basis of merit. Education shall be directed to the full development of the human personality and to the strengthening of respect for human rights and fundamental freedoms. It shall promote understanding, tolerance and friendship among all nations, racial or religious groups, and shall further the activities of the United Nations for the maintenance of peace. Parents have a prior right to choose the kind of education that shall be given to their children. Article 27. Everyone has the right freely to participate in the cultural life of the community, to enjoy the arts and to share in scientific advancement and its benefits. Everyone has the right to the protection of the moral and material interests resulting from any scientific, literary or artistic production of which he is the author. Article 28. Everyone is entitled to a social and international order in which the rights and freedoms set forth in this declaration can be fully realized. Article 29. Everyone has duties to the community in which alone the free and full development of his personality is possible. In the exercise of his rights and freedoms, everyone shall be subject only to such limitations as are determined by law solely for the purpose of securing due recognition and respect for the rights and freedoms of others and of meeting the just requirements of morality, public order and the general welfare in a democratic society. These rights and freedoms may in no case be exercised contrary to the purposes and principles of the United Nations. Article 30. Nothing in this declaration may be interpreted as implying for any state, group or person any right to engage in any activity or to perform any act aimed at the destruction of any of the rights and freedoms set forth herein.
Generations of human rights. 3 generations. A. International Covenant on Civil and Political Rights and 2 Protocols. B. International Covenant on Economic, Social, and Cultural Rights. C. Collective Rights. International Covenant on Civil and Political Rights, ICPER, and 2 Protocols. International Covenant on Civil and Political Rights, ICPER. First Generation Rights. ICPER, also known as General Rights. Rights contained in the Covenants of Civil Political came under this category that see their origin in 13th century in Magna Carta. Example: equality, freedom, right to life, no slavery, no torture, recognition. International Covenant on Economic, Social, and Cultural Rights, ICESCR. Second Generation Rights. ICESCR rights refer to economic and social rights which are considered to have been originated in the Russian Revolution in 1917 and in the Paris Peace Conference in 1919. Example: food, freedom from hunger, work, rest, well-being. The ICESCR is a part of International Bill of Human Rights along with the UDHR and ICPER. The Covenant is monitored by the UN Committee on Economic, Social and Cultural Rights. The ICESCR has its roots in the same process that led to the UDHR. ICESCR was adopted by the UN General Assembly on December 16, 1966 and came into effect on 03 January 1976. ICESCR consists of preamble and 31 articles. Part 1, Article 1. Recognizes the rights of all peoples to self-determination, including the right to pursue their economic, social, and cultural goals, manage and dispose of their own resources, determine their political status. Part 2, Article 2 to 5. On principles of progressive realization. Right recognized without discrimination of race, color, SEC, language, religion, political or others. Part 3, Article 6 to 15. Work under just and favorable conditions. Right to form and join trade unions. Social security, including social insurance. An adequate standard of living. Participation in cultural life. Part 4, Article 16 to 25. Concerns reporting and monitoring of the Covenant and the steps taken by the parties implement it. Part 5, Article 26 to 31. Govern ratification, entry into force amendment of the Covenant. Difference ICPER and ICESCR. Basis. ICPER. ICESCR. Generation. First generation rights. Second generation rights. Scope. Only talks about civil and political rights. Only talks about economic, social, and cultural rights. Inclined. Western countries more inclined to civil and political rights. Eastern countries more inclined to economic, social, and cultural rights. Collective rights, third generation rights. All rights, also known as group rights. These are the rights which belong to all people so that members of all groups may be benefited. These are the rights which do not rest in, nor is exercised by an individual alone, like traditional rights. The concept of collective rights emerged because individual human rights do not guarantee adequate protection for indigenous people. Collective rights guarantee the development and preservation of minorities and form of organization. Various kind of collective rights. Right to development. encompasses the development of economic, social, cultural, and political process for the development of the personality of human being. Right to self-determination. Right to safe environment. As pollution affects adversely the quality of human life as well as animals, plants, and industries. European Convention on Human Rights and Fundamental Freedoms, ECHR. The European Convention on Human Rights, ECHR, is an international convention to protect human rights and political freedoms in Europe. Drafted in 1950 by the then newly formed Council of Europe, the convention entered into force on September 3, 1953. All Council of Europe member states are party to the convention and new members are expected to ratify the convention at the earliest opportunity. The convention established the European Court of Human Rights, ECHR. Any person who feels their rights have been violated under the convention by a state party can take a case to the court. Judgments finding violations are binding on the states concerned and they are obliged to execute them. The Committee of Ministers of the Council of Europe monitors the execution of judgments, particularly to ensure payment of the amounts awarded by the court to the applicants in compensation for the damage they have sustained. The convention has had a significant influence on the law in Council of Europe member countries and is widely considered the most effective international treaty for human rights protection. ECHR has 18 articles and 14 protocols. American Convention on Human Rights. The American Convention on Human Rights, also known as the Pact of San Jose, is an international human rights instrument. It was adopted by many countries in the Western Hemisphere in San Jose, Costa Rica, on November 22, 1969. It came into force after the 11th instrument of ratification, that of Grenada, was deposited on July 18, 1978. The bodies responsible for overseeing compliance with the convention are the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights, both of which are organs of the Organization of American States, OAS. According to its preamble, the purpose of the convention is to consolidate in this hemisphere, within the framework of democratic institutions, a system of personal liberty and social justice based on respect for the essential rights of man. National human rights institutions with special reference to National Human Rights Commission, NHRC, and National Commission for Women, NCW. National Human Rights Commission, NHRC. The National Human Rights Commission, NHRC, of India is a statutory public body constituted on October 12, 1993 under the Protection of Human Rights Ordinance of September 28, 1993. It was given a statutory basis by the Protection of Human Rights Act, 1993, PHRA. The NHRC is the National Human Rights Commission of India, responsible for the protection and promotion of human rights, defined by the Act as rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. Functions of NHRC. The Protection of Human Rights Act mandates the NHRC to perform the following: proactively or reactively inquire into violations of human rights by Government of India or negligence of such violation by a public servant. The protection of human rights and recommend measures for their effective implementation. Review the factors, including acts of terrorism that inhibit the enjoyment of human rights and recommend appropriate remedial measures. To study treaties and other international instruments on human rights and make recommendations for their effective implementation. Undertake and promote research in the field of human rights. To visit jails and study the condition of inmates. Engage in human rights education among various sections of society and promote awareness of the safeguards available for the protection of these rights through publications, the media, seminars, and other available means. Encourage the efforts of NGOs and institutions that works in the field of human rights voluntarily. Considering the necessity for the protection of human rights. Requisitioning any public record or copy thereof from any court or office. Composition. The NHRC consists of the chairperson and 5 members, excluding the ex officio members. A chairperson, who has been a Chief Justice of India or a judge of the Supreme Court. 1 member who is, or has been, a judge of the Supreme Court of India, or 1 member who is, or has been, the Chief Justice of a High Court. 3 members, out of which at least 1 shall be a woman, to be appointed from amongst persons having knowledge of, or practical experience in, matters relating to human rights. National Commission for Women, NCW. The National Commission for Women, NCW. The National Commission for Women, NCW, is the statutory body of the Government of India, generally concerned with advising the government on all policy matters affecting women. It was established on January 31, 1992 under the provisions of the Indian Constitution, as defined in the 1990 National Commission for Women Act. The first head of the commission was Jayanti Patnaik. As of November 30, 2018, Rekha Sharma is the chairperson. The objective of the NCW is to represent the rights of women in India and to provide a voice for their issues and concerns. The subjects of their campaigns have included dowry, politics, religion, equal representation for women in jobs, and the exploitation of women for labor, police abuses against women, inclusion of human rights jurisprudence under the Constitution of India through judicial interpretation. Introduction. The purpose of the Constitution is to bring social resolution.
The Constitution of India, in this regards, can be seen as one of the most elaborate fundamental laws ever adopted. Constitution is termed as the fundamental law of the land. The human rights enumerated under it are termed as human rights. Right relating to life, liberty, equality, dignity for individual. Keshwanand Bharti v. State of Kerala. The Supreme Court observed that UDHR may not be a legally binding instrument, but it shows how India understood the nature of human rights at the time the Constitution was adopted. Chairman, Railway Board and others v. Mrs. Chaudhary Madas. The Supreme Court observed that the applicability of the UDHR and principles, recognized as the moral code of conduct thereof, may have to be read, if need be, into the domestic jurisprudence. Preamble to the Constitution and Human Rights. The preamble of the Constitution declares India to be a sovereign, socialist, secular and democratic republic. The term democratic denotes that the government gets its authority from the will of the people. It gives its authority from the will of the people. It gives a feeling that they all are equal, irrespective of the race, religion, language, sex and culture. The preamble to the Constitution pledges justice, social, economic and political, liberty of thought, expression, belief, faith, worship, equality of status and of opportunity and fraternity, assuring the dignity of the individual and the unity and integrity of the nation to all its citizens. Fundamental Right and Human Right. Part 3 of the Constitution. Fundamental rights are different from ordinary rights in the same as they are inviolable. No law, ordinance, custom, usage as administrative order can abridge or take away. Any law that violates any of the fundamental rights is void. In ADM Jabalpur v. Shukla, Court observed that the object of making certain general aspects of rights fundamental is to guarantee them against illegal invasion of these rights by executive, leg or judicial organ of the state.
Golanath v. State of Punjab. Court observed that fundamental rights are the modern name for what have been traditionally known as natural rights. The right to constitutional remedies. Article 32 is a fundamental as well as constitutional remedy. The Supreme Court is vested with wide constitutional powers in this regard, includes the power to issue directions, orders or writs for the enforcement of the fundamental rights. State High Court too have identical powers, Article 226. Chairman Railway Board and other v. Chandra Madas. The Supreme Court observed that, fundamental rights are available to all the persons of this country and those who are not allies of the country, Article 21. Monica Gandhi v. Union of India. The expression personal liberty in Article 21 is the widest amplitude and it covers a variety of rights. Right to privacy, Article 21 and 19, 1, d. This right is stipulated under Article 17 paragraph a of the Covenant on Civil and Political Rights.